We had a plea that was submitted on that.
Okay.
Or yeah, see, he's on here.
Let's see. Mr. Dobbs.
Yeah.
Brett Dobbs.
Yes, sir. I got it. Yes, sir.
There you are. Okay.
Yes, sir.
Gotcha. All right. Mike, are you telling me you all have an agreement here?
Yes, sir. There should be some. There was paperwork that was filed that should be in the file.
I do not have it. Did you e-file it?
Xanda did.
I did, Your Honor. I e-filed it, I believe, last Thursday or Friday.
All right. I'll just have to get them to get on there and try to pull it off.
If you need me to email it to Christy, I can do that.
Well, we're going to find out. Right now, I'm going to see if Jen can just print it from the bench clerk spot here. Yeah, it's all right. Dobbs, can you go ahead then and raise your right hand?
Yes, sir.
You swear or affirm that you will tell me the truth, so help you God.
Yes, sir.
All right, thank you.
No.
I'm going to show you a couple of different things here that I need you to look at, kind of going backwards because they didn't print out in the normal order here. This is a document that is called the Commonwealth's offer on a plea of guilty. Does that document look familiar to you?
Yes, sir.
And does it, in fact, contain your signature?
Yes, sir.
Okay. This is a document that's called motion to enter a guilty plea. You see it's got your name on it. It's got your case
I'm waiting for my turn in court.
case number on it. And again, is that your signature?
Yes, sir.
Very good. Did you make sure that you understood what these documents said before you signed them?
Yes, sir.
Did you have time to discuss them with your attorney if you needed to, and to ask any kinds of questions that you needed to ask?
Yes, sir.
All right. Are you comfortable that you've had ample time to decide how to proceed and that you have not been pressured into entering this agreement?
Yes, sir.
You feel like I have made you enter an agreement?
No, sir.
Okay. You feel like your judgment is under or is impaired for any reason today?
No, sir.
All right. Mr. Dobbs, do you understand that you have the right not to incriminate yourself? And if you voluntarily plead guilty, that constitutes a waiver of that right. Do you understand?
Yeah. Yes, sir.
Okay. You have the right to a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine the people that give evidence against you, as well as the right to put evidence on in your own defense. You have the right to appeal the outcome of the proceedings to a higher court. Do you understand that with respect to each of those rights, you would waive them by pleading guilty?
Yes, sir.
All right. Mr. Dobbs, the Commonwealth's offer appears to be as follows. And listen real close, because you and I both need to think that this says the same thing before we get done. Count one, possession of a controlled substance, first degree, first offense. That's a Class D felony. The Commonwealth, as part of its comprehensive plea offer here, agrees to dismiss that charge on your plea of guilty to count two, drug paraphernalia, which would result in a recommendation of 12-month sentence, and count three, possession of, public intoxication, a B misdemeanor, which would result in a 90-day recommended sentence. The 90 days and 12 months would run concurrently for a total recommended sentence of 12 months, plus a possible fine and court costs. The Commonwealth agrees to probate that sentence of 12 months without supervision for a period of 2 years. What that means is that you're on probation, which is kind of a don't get in any more trouble type of probation. You aren't reporting to a probation officer or going to a certain place at a certain time or anything like that.
Right.
And we can talk a little bit more about what that entails. But that's the gist of it. Is that what you thought you were agreeing to?
Yes, sir.
Did you believe that you were threatened by anyone
No,
or
no,
made
sir.
any promises other than the Commonwealth's promises to make those recommendations to me?
No, sir.
Okay. Mr. Dobbs, let me ask you again, do you feel like you are being forced by me to plead guilty?
No, sir.
All right. Are you acknowledging to me that on or about October 21st, 2019 in Barron County, Kentucky, you used or possessed with the intent to use drug paraphernalia?
Yes, sir.
Are you also acknowledging to me that at that same time and place, you appeared in a public place manifestly under the influence of a substance other than alcohol, which to a degree that you might have been considered a danger to yourself or to other persons or unreasonably annoying other persons in the vicinity?
Yes, sir.
Okay, Mr. Dobbs, I will accept today your plea of guilty because this is a misdemeanor and the felony charge is going to be dismissed. We would just go ahead and sentence you at the same time. So I will sentence you to the 12 months recommended by the Commonwealth and agreed to by you. I'll grant your implicit request to probate that sentence for a period of 2 years on the condition that you have no further violations of the penal code or any drug laws, and that
Okay.
you don't have any new arrests or convictions. Okay.
Yes, sir.
All right.
Judge,
Yes.
I'm sorry, Judge, I don't mean to interrupt, but I just wanted to put on the record, the reason we're dismissing the possession charge is because it was 2 hydrocodone pills that were found in Miss Myers. It was 2 different markings and they showed prescriptions for himself and his mother that covered those markings. And due to the facts and circumstances as to how they were found, that there wasn't any other pills and nothing else was found on him, I went ahead and dismissed that charge on that basis.
All right.
Thank you, sir.
Yeah, that's fair.
Your Honor, additionally, part of the agreement, what we had negotiated was that he would have his firearm and ammo that was seized by police returned. I don't know if we need a separate agreed order for that or if it would just automatically be returned.
What I will do in the judgment that we do is we will put in there that upon his proof of identification, he can get those things back. So it'll just wait. He'll have to wait till the judgment gets entered, which should be anytime in the next 2 or 3 days. And then
Okay.
you'll have to take a copy of that judgment and a driver's license or whatever ID you've got and go to, and I don't know what entity was holding all this. Was it PD?
City. GPD, yes, sir.
Yeah, GPD. So you just have to take it to the Glasgow Police Department. And I'm going to be perfectly frank with you as far as I don't know whether you go out to the police department out on Happy Valley Road or if you go down here to the evidence tech spot down here on College Street. I don't know which one you go to, but if you go to the wrong one, they'll tell you to go to the other one.
I'm sure they'll point me in the right direction. Yes,
Yeah.
sir.
Yeah. Okay.
Yes, sir.
All right. Anything else?
So, thank you, Ms. Myers.
All right. Thank you. Good luck, sir.
Thank you. Thank you, Your Honor. Thank you, Mr. Richards.
Welcome.
Yeah. Somebody should have caught that. Probably me. All right. Okay, who's up next?
Judge, I see Misty Wilson is on. She's a rocket docket plea.
Okay.
And before we start, I just got off district court, and there are two people, Daryl England and Kara Horton, who are supposed to enter pleas. They appeared in district court, and neither of them have talked to their attorney about filling out the paperwork, so they won't be on this afternoon.
All right. I also wanted to point out to you guys, we have Crystal Crockett is on here. She does not show up on the docket, and that was just a mistake, but
She was on last week.
yeah, and we moved it to this week, but I cannot recall why, but we did. But it didn't get on the docket because I wrote the wrong date down on her. Whenever the clerk was putting in the docket, they went by what I wrote down, and I did not write down April 19th. I wrote the wrong month. So I don't know if we need to go ahead and address her in just a minute. We'll do this rocket docket first, but or if we're ready to go on hers, I'll just leave that up to you all. Misty Wilson.
Yes.
All right. Can you hear me?
Yes, Your Honor.
Good deal. Will you raise your right hand, please? Do you swear to tell me the truth, so help you God?
Yes, Your Honor.
All right, thank you. Miss Wilson, there's a bunch of things we need to talk about paperwork wise here, okay?
Yes, Your Honor.
The first thing is and I say first, I mean, it doesn't really matter what's first, but old habits die hard, so I go in a certain direction here. This is a document that is entitled Motion to Enter a Guilty Plea. Does that look kind of familiar to you?
Yes, Your Honor.
Okay. Probably the way this was done, if my past experience with these COVID era deals is that you probably looked at this and maybe your attorney talked with you about it on the phone. And then you theoretically would have given him verbal authorization to put your signature on that. That is not an actual signature. That's a virtual signature. Is that true?
Yes, Your Honor.
So you did give him your authority to do that?
Yes, Your Honor.
Okay. The second document, which was handled in a similar fashion, is this situation here that's called the Commonwealth's offer on a plea of guilty.
Yes, Your Honor.
All right. Got your name on it and so forth, got your charges on it. And if you get over here to the second page, it's got, again, kind of an electrical or electronic signature, right? So did you authorize your attorney to put your name on that document also?
Yes, Your Honor.
Very good. The third thing is this document that's called a waiver of rights. It is several pages long, but at the end, we got the same kind of signature on it. So same question.
Yes, Your Honor.
You authorized him to do that. All right. So did you go over all these things before you authorized anybody to put your virtual signature on them?
Yes, Your Honor.
All right. Do you understand that nobody can make you enter a guilty plea? And if you do so, it has to be your voluntary decision.
Yes, Your Honor.
Do you feel like anybody has made you or has attempted to make you enter a guilty plea today?
No, Your Honor.
Okay. Do you understand that if you plead guilty, you have certain constitutional rights which you are waiving?
Yes, Your Honor.
Okay. You waive the right not to incriminate yourself. You waive the right to have a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You waive the right to confront and cross-examine witnesses. You waive the right to put evidence on in your own defense, and you waive the right to appeal. Do you understand that?
Yes, Your Honor.
Okay. Now, Ms. Wilson, do you feel like your judgment is impaired for any reason today?
No, Your Honor.
Do you feel like you're under the influence of anything or for any other reason unable to think clearly?
No, Your Honor.
Very good. So in this case, the Commonwealth has agreed to make the following recommendations from what it appears to me. Count one is possession of a controlled substance, first degree, first offense. That is a Class D felony, and the Commonwealth agrees to recommend a sentence of 1 year. Count two is possession of a controlled substance, third degree. That is a misdemeanor, Class B misdemeanor, or Class A misdemeanor. the Commonwealth agrees to recommend a sentence of 12 months. Uh, Count 3 is driving under the influence, first degree. That is a B misdemeanor. The Commonwealth agrees to recommend, but this amounts to the standard first offense DUI penalties, which is a 30-day sentence with 28 days suspended, a service fee of $425, a fine, court costs, DUI counseling for a first offense, and a license suspension as administered by the Transportation Cabinet, right?
Yes.
And the let's see, and that's all of the charges that you would be pleading guilty to. As part of the plea offer, the Commonwealth would agree to dismiss failure to produce insurance card, no seat belt, 2 counts of possession of a controlled substance, first degree, possession of controlled substance prescription not in the original container, no insurance, first offense. So the Commonwealth would agree to dismiss all of those charges on your plea of guilty to the 3 charges that we just talked about. Is that what you understood?
Yes, Your Honor.
And
Judge, just,
go ahead.
I was just going to put on the record, she did provide proof of insurance. So
Okay.
that's why that was dismissed.
Okay. All right. So other than that, Ms. Wilson, has anybody promised you anything or threatened you to try to get you to plead guilty?
No, Your Honor.
All right. Are you pleading guilty because you believe I'm making you?
No, Your Honor.
All right. Are you in fact pleading guilty voluntarily and of your own free will after consultation with counsel?
Yes, Your Honor.
Okay. Do you acknowledge to me that on or about the 4th day of February 2021 in Barron County, Kentucky, you knowingly and unlawfully possessed a Schedule II controlled substance, methamphetamine, and a Schedule II controlled substance, hydrocodone, constituting possession of a controlled substance, first degree?
Yes, Your Honor.
Are you also acknowledging to me that you possessed knowingly and unlawfully Lyrica and gabapentin, each of which is a Schedule V controlled substance, constituting possession controlled substance in the 3rd degree?
Yes, Your Honor.
Are you also acknowledging that at that time and place, you were operating or in control of a motor vehicle while under the influence of a substance or combination thereof that impairs your ability to drive, and it was a first offense?
Yes, Your Honor.
All right, good enough. So I am going to accept your plea of guilty here today. I did kind of forget to bring this part up, but this is typical for a rocket docket, so I guess that's why I skipped over it. But the Commonwealth is going to recommend probation of your sentence, and that's the offer that they have made to you, is that if you enter this guilty plea, they will recommend those sentences and they'll ask for that to be probated. So the probation would be conditioned on you following the terms and conditions of probation, which makes sense, right? And specifically because this involves substances, it would also have a component where they will schedule an assessment to see if there's any treatment that needs to be done. And if there is any recommendation, that'll be part of your probation that you do that. Okay.
Yes, Your Honor.
All right. Fair enough. So that doesn't change anything, does it? That you understood that was what you were agreeing to, right?
Yes, Your Honor.
Okay. Then I'm going to accept your plea of guilty here today. I believe that you understand what you are doing and that this is on the face a fair offer from the Commonwealth. Makes sense that you would accept it. I will enter a judgment accordingly, and we will dismiss the seat belt, no insurance card, no insurance, the remaining controlled substance charges. Upon entry of the judgment, those charges will be dismissed. Ms. Wilson, we've got a probation officer on here, and since you're gonna, I would assume you want me to just go ahead and tell you that you're going to be probated today rather than make you wait to find that out later. So that's what we'll do. And then we'll let the probation officer jump on here and tell you when he needs to see you. Okay.
All right. All right.
All right.
Thank you so much, Your Honor.
Officer Bennett.
Yes, Judge.
Well, he's got a real like impressionistic thing going on there with this. Did you? Did you rub something on you?
No, I was supposed to get a new computer and I opened it up and the camera's all messed up. So it's great. It's great.
Yeah, I mean,
Basically like underwater looks like. It's fine.
yeah, it looks like we're shooting you through an aquarium.
Yeah. Thanks, Judge. Miss Wilson.
Oh, thank you. It works a lot better this way.
Miss Wilson, if you don't mind, give me a call. Do you have something you can take my state cell phone number on, please?
Yes, sir. What is it?
Okay. It is 270
Uh-huh.
791
791
4940.
4940. Okay. And go ahead and call you now.
Yeah, just whenever you get a chance, give me a call.
Okay, I will do. Thank you so much.
All right, Miss Wilson, you're free to go. Thank you.
All right. Thank you, Your Honor. Have a good day.
You too.
Thanks.
I just thought of it. Miss Gardner, did you have a specific idea on those other two rocket dockets, or are we just going to wait and see if they talk to their lawyer and then you'll call and tell us when you want them back on?
I think we're going to wait and see. I think they should be able to be put on next Monday. Daryl England's in a treatment center, and I emailed him the paperwork because his attorney's sick today. So I emailed it right to him and gave the attorney's email and phone number. So hopefully that will get done this week.
All right. Let me see. Who else do we have? I do have the jail up in Elizabethtown got on here. If I think I only have one defendant there, so we might be able to go ahead and address that. And then I keep seeing Mr. Duval on here. Greg's his lawyer, and Greg, we had to move that. I don't know. Denise, I think it was May 3rd. I don't know if one of y'all wants to maybe direct chat him and tell him that his case has been moved, because his camera's off, so I can't tell if he's paying any attention.
Yes, sir.
I think it was May 3rd. All right, so this is going to be 20 CR 167, Catherine Ayatides from the jail up in Hardin County. This is the Commonwealth's motion to revoke probation. The motion is based upon a new felony arrest occurring 2 or 3 weeks after the case down here was probated. Ms. Gardner, is this yours?
Judge, it's mine.
Oh, okay, I'm sorry. I got sidetracked because I was talking to her about that other case, and I don't know why in my mind I thought she had this one. All right, Mr. Gardner, what are you asking for this to go on for a hearing?
Yes, Your Honor.
All right. Who is this Greg's case originally?
This is Greg's as well, yes.
All right, so we're going to go ahead and set this for next Tuesday, April 27th. Subject to availability, but we'll inquire about that up and find out. (4/27) at 1:30 Central Time for a hearing on the Commonwealth's motion. Okay? All right.
Okay.
Thank you.
I have a question.
Yes.
My bond here is paid. Will I be transferred to Barron County, or will I be just doing it here?
I do not know the answer to that. I mean, that's kind of between the jails what they do.
Okay, I didn't know.
Okay. All right.
All right, thank you.
All right, let's see.
Judge, I think we got Zach Williams on from Bell Forestry.
You sure might.
You do, Your Honor.
Okay, good deal. All right. Mr. Spears,
Yes.
what is our situation?
Judge, he is going to enter a plea today. The paperwork got sent several weeks ago when we thought we were going to have Bell Forestry on, so there should be paperwork in the file. Let me guess there's not.
Well,
Oh, crap. Good boy.
I don't see it, but let me keep looking.
All right, let me look and see if I can find it. I'll send it to Cape. I can send it to Chrissy.
Well, if you're like me, you have to do that because that's the only way you can see out of your glasses. Yeah, I don't have anything in the file. I can pull up I guess I can pull up my email and see if I ever got an email about it. I do not. Nope, I got nothing. Yeah. All right, well, yeah, while we're looking for those things, let's see if there's anybody else has something that they can do.
Your Honor, I see that Taryn Hill is on here, and I know that I believe Greg Price had been appointed to her as conflict counsel.
Yeah,
We haven't had any conversations about it, so I don't believe we'll be able to do anything today.
Mr. Price was on here a minute. Yeah, there he is. He's back.
Your Honor, I'm just popping in here and I am checking my files, and I apologize. I didn't have this on my calendar, and it is probably because I just got conflicted onto it.
I didn't even know that he had been appointed to me. I thought that the man from Hardin County was the one representing me, but I could be wrong.
No, she's correct. It is from another office.
I think it's Hardin County.
Oh, okay.
Because I had Brad Gordon, and then I think he transferred to a different office, and they gave me Andrew Rhodes.
Okay.
And I didn't see
That's
him on here because
right.
I checked the participants, and I don't see him on here. So
That's right.
I don't know.
It's
what,
very confusing.
yes, and I am still here at the Hope Center. So
How long are you going to be there?
well, I'm on a 2-month contract right now.
When
So
does that end?
May 9th.
May 9th.
May 9th.
Jen, could we maybe pass her to May the 24th?
And I mean, fingers crossed, I will be done with phase 1 on May 24th. I should be. I mean, I thought I already would be done. And then, I don't know if y'all know how rehab facilities work, but you get like contracts for community. It's like a part of the program. And that's what I'm on right now. They thought that I wasn't ready to be done with phase 1 yet. So I am on contract. It's the first, I guess it would be considered a setback. I don't really know. It's not for consequences. It's just part of the program. If they don't think you're ready, they don't complete you.
All right.
And they didn't think that I was ready. So.
I guess let's step back and find out. I would like to find out, were we incorrect that Mr. Price has this one, or does he have it and he just now found out?
No, I was wrong.
Okay. So
I always blame the Commonwealth, Your Honor.
No wonder he
Wouldn't be the first time.
no wonder he was scrambling around admirably trying to figure out what was going on.
I told Mr. Rhodes that I had court today. I've talked to him. I told him many times, so I'm not really sure what's going on.
Your Honor, and I don't mean to overstep, but I know that Corey's over here. I have his number. If y'all want to pass it, I can pass him a message saying that we're going to pass Ms. Hill to a certain date.
Well, yeah, I think everybody agrees that we need to
I've
pass
been
it.
chatting with.
Yeah.
Okay.
Yeah.
What we're wanting to do, I think what Ms. Gardner's wanting to do is let Taryn get through this phase 1, see if she accomplishes that, which it sounds like she probably will if we go over to May 24th. And then we will try. Now, are you expecting that you'll be completely out of that place, or you'll just have finished one phase but still be in there doing something?
See, phase 1 is the only thing I'm required to do, but considering whatever offer I get with this, I'm going to go on and go into phase 2 and peer mentor here at the Hope Center until I know, what's going on with my court case. And then, if I go back to jail and do my time, then obviously that's where I'll go. And, depending on my offer, I'm going to stay here and peer mentor and do the work program and complete phase 2 as well.
Well, thriving and continuing to thrive in your current setting can certainly not hurt you. So
Right.
Keep that in mind.
Yes, sir.
Even if it's not for strategic reasons, it's just so that you can get tools you need to not be worried about that stuff when you do get out.
Okay, now
Right,
I
I'm
can
most
hear.
definitely staying here. Yeah, I'm most definitely staying here. They have a building next door, like you can transition and you get your own apartment. So I'm doing that route until. Just gonna
All
stay
right.
here.
So we're going to say May 24th at 1 o'clock.
Okay.
And Ms. Hill, the reason I was asking all these questions is because by that time we should be having most of what we're doing in person. But if you're in a facility, we'll still let you meet.
Okay.
Because it's hard for you to get here.
Right. If I'm completed with phase 1, my mom would most definitely bring me if you all wanted me there in person. But if it was possible to do it over Zoom, that would save me a 2-hour drive. But that's just up to you all, however you all want to do it.
Well, maybe if there's any way possible to talk to your lawyer and see what he wants,
Okay.
that'd be the
Yes,
way
sir.
to do it. All
Yes,
right.
sir.
Because
Okay,
you all
thank
could, there could be something worked out. And if you have something
Right.
worked out, you'd be better off coming in person and doing it,
Right. Right.
Okay.
Okay. Thank you,
All right.
Your Honor.
All right. Super. Thank you.
And Ms. Gardner, did you say you were in contact with her attorney, or did you want me to take care of that?
I'll email him.
All right, thank you.
Thank
So that Brad Gordon dude's out because he moved. I just don't remember I don't know the name of the other person. I can't tell if she's saying Rhodes or Rose, like Rhodes, R-H-O-D-E, or Rose, like R-O-S-E.
That's what I.
Well, the answer just isn't real clear. Well, I'm not sure. All right, let's see. Any of the rest of you got one you want to do?
Johnny has other cases, but I see Chris Holder on here. Or at least his name.
Yeah,
Yeah, I can do something, Judge.
I think I'm here. All right.
I think you are too.
All right. I got it.
The heck? All right, all right,
Let's see here.
all right. All right, Mr. Holder. We're on for free trial, isn't it, Mr. Bell?
Judge, we had, I met with Mr. Holder last week. We got an affidavit we sent over to the Commonwealth concerning the case. I don't know if they've had time to review it or think about it. I know we hadn't talked to them. We sent it late last week. May even been.
Judge, I have gotten that affidavit. It doesn't change the Commonwealth's position as far as the evidence or the offer in this case at this point.
Well, if that's the case, Judge, I guess we just need to move forward with a trial date.
Okay.
Johnny, I mean, we've made an offer. You've never made a counter offer as well. So, I mean,
Well, okay,
but as far as, I mean,
Judge, I'm sorry.
the affidavit comes from his wife who says that she, he didn't have possession of this gun, but his father-in-law said he heard shots fired from the residence. He's holed up in the residence for several hours. Guns found in the residence, shell casings found in the residence, and deputies will testify that the gun smelled like it was freshly fired as well. So,
Well, it was found in a safe, but Judge, Mr. Gardner is right, and I apologize. I think I've got about 6 different jurisdictions I'm trying to do today. If we could get another pretrial, I would gladly make a counter offer and try to work with Mr. Gardner to get this case resolved.
Can you do May the 10th?
Let me check, Judge, because everything's going back in person.
Not that I'm your secretary, but I'm thinking May the 10th, we scheduled a bunch of things for you and you said you thought you might have had a trial, but if we were going to move one thing, we might as well move 3 or 4.
Yeah, so that's correct. I do have things scheduled with you both 1 o'clock and 10 o'clock. I'd ask this be put on at 10 if we could.
That does not bother me.
Now, I apologize, John. I should have sent you a counter offer on that and thought I'd taken care of that, but
So,
see that hadn't. John
special
Gardner.
circumstances, we'll do 10 o'clock. Okay. Instead of 1. All right. We should be meeting in person at that time, Mr. Holder. All right.
Yes, sir.
All right. See you on May 10 o'clock.
Right.
Yeah. I do have, you want me to keep going with people I've got here?
Yeah.
I've got Bobby Canaster here, Judge. Hey, Bob.
How you doing?
All right, here you go.
Thank you.
We all dressed up sharp, ain't
Yeah, we thought we dressed up for
you?
you.
Yeah, everybody was telling tired.
Let me sit right here, Johnny.
Yeah, you fine.
Johnny, does he, the last letter the clerk sent to him about a rescheduled court date came back. Does he have a new address?
Yeah, yes, now, Bobby.
4474 Lake Branch, Burkesville Road.
It's 4474
Burkesville Road.
Burkesville Road, Your Honor. Of course, that's Glasgow, Kentucky.
It's not too awful far, but it ain't the same road.
What road, did y'all have a Canasta
Branch.
Road?
Yeah, that Lick Branch address.
No, they moved from there, Judge. They're now residing at 4474 Burkesville Road.
Yeah, we got it.
All right.
Judge, I mean, you're well aware of this case. We've tried to mediate it unsuccessfully. I think at this point, all the discovery's in, and we had a trial date that got canceled due to COVID, and we just need new trial dates.
Yeah, that's what I was looking for. I couldn't remember whether I knew we had to cancel the last trial, but we didn't reschedule it, did we? So we need.
I don't think so.
No, we didn't.
Oh, mercy.
I think that's how we're all starting to feel, Judge. Time to pay the piper.
Yeah. Question then, how do you all feel about, I mean, what, we have 4 days set for it?
That's correct. I'd say it'll take a good 4, if not 5, don't you, John?
It's just all gonna depend on what the, regulations are at that time, and
Yeah. And I do
we can
have,
try it like normal. I think 4 days could do it if we have to, still at that point have the COVID restraints. It's probably gonna be more like 5.
Well,
I think that's it.
of course, the proof of the pudding is in the eating, as they say, but I mean, I think that we've put a lot of work into trying to get a trial, a jury selection. That's the part that's gonna take longer, and we've put a lot of work into trying to get something that'll work out. So I believe that we are gonna be okay with doing that. And it ain't gonna add a ton of time to everything that we're doing. But, like they say, even the best plans rarely survive first contact with the enemy. So we'll have to have a trial first and see if our plans work, before we know for sure. I'm just trying to get, I know I could do, as long as you all could do it, I know I could do the first, well, I mean, it would be the first week of December. It would actually be November the 30th and then December 1st, 2nd, 3rd. And that'd really be about all I would have as far as 4 days. Now, if I had to, I could bump a civil trial or something, but what I'm concerned about is we have a murder trial already in like October, or like we have one in September and one in October, and then this one would be November, December. I kind of hate to do too many just because I'm afraid that wouldn't end up being fair to somebody to have the same jury hearing a bunch of those at once,
John, would you have any objection that late to just moving it on over to 1st of January?
Are there dates available in January, Judge?
Well, now, yeah, here's the situation with January is I've got a medical malpractice trial that is set for the whole month of January that we don't have rule days on. And then I've got a medical malpractice trial that's set for the whole month of February that we don't have ruled. I mean, these are like 4-week trials. And then I've got a trial every week in March. There's 4 different trials. Now they're civil trials. I mean, if I bumped them and I bumped them this far in advance, I mean, everybody knows that criminal trials can bump civil trials. I mean, the civil lawyers know that. So if I gave it to them that far in advance, maybe they wouldn't be happy about it, but they just have to live with it.
My position is, Your Honor, and Mr. Gardner, in this situation, I would ask that we go to January, get a good solid date with plenty of time, even maybe, if you're going to bump something, and we could get us 5 days, and that way we could be for certain that we was going to conclude this case, and at this point, that's something I think we need to do.
When I say bumping a civil trial, I mean, I'm not going to bump a trial that I've got a month for, because they've already subpoenaed. I mean, their expert witnesses are all over the world. I mean, they've got these people lined up. There's something like 14 medical experts in that case. So I'm not going to upset their apple cart.
Yes.
But I mean, some of these car wreck cases and that kind of thing, that it's set a year out, so they haven't subpoenaed anybody, and they're not, I would just have to tell them that we were moving their date.
So we're looking at either December or March, is that correct?
We'd be looking at either December or all right, so my problem with March, since you're saying 5 days, is that we have no 5-day weeks. So I've got a trial every week. So if I do March, then I'm bumping 2 trials because I'm getting stealing some days out of 1 week and stealing some days out of another week. If I do April, I've got, some 4-day weeks and, some 4-day stretches in there. But then if I do 5 days, I've got to cancel somebody's trial just to steal a day from them.
Well, I guess we just need to keep it at 4, and that we could probably conclude it in that. I was just thinking, I didn't know that the calendar was that tight. But.
No,
Judge, I mean,
I'm not faulting you. I'm just trying to explain to y'all what my challenge is.
Yes, sir.
if we put it over in March, we're looking at, this case it's an 18 case. So, I mean, that'd be 4 years at that point. I know that, COVID has stepped in here and caused plans to go a little bit awry, but I mean, I'm not a big fan of trying cases that time of year, but I don't want to go until March.
Well, I think we have had some experiences with trying something in December. And of course, the peril was getting it later in December where you were running out of time. I mean, having the first, November 30th and then December 1st, 2nd, and 3rd. I mean, I don't really foresee us getting into a big problem there. I don't think anybody's gonna.
I've just never had real good luck during anything from Thanksgiving to the first of the year. Has always been a difficult time, it seems, in my tenure. But of course, I'll do whatever we agree upon doing.
I really can't do.
I'll leave it up to you, John. You want to do the December, we'll be ready, and if not, we'll move on.
I've stated my preference. I mean, ultimately it'd be up to the judge.
I think all other things being equal, and I know this isn't everybody's ideal, but desperate times call for desperate measures, and that's kind of where we are. I think we need to put it on that November 30th and then December 1st, 2nd, 3rd, that 4-day stretch. I think we'll have all of our kinks worked. I really don't see, if I can't get it in then, it's going to be another 4 or 5 months after that. I think that's plenty of time for us to get ready for it. That's 4 months, 6 months, 7 months, 8 months from now. It's the first thing that we've got. And so I think that's where we are.
We're gonna have one more pre-trial, or have we pre-trialed it enough?
Well, I don't mind having one just because some issues might come up, maybe 2 months before the trial, 6 weeks before the trial, something like that, just in case something comes up. But I wouldn't expect anything necessarily to get done at that point. But I don't like setting something 8 months away and not having at least one more pretrial before it. So why don't we set one we can do October 11th. That work? At 1 o'clock?
Yes, sir.
All right. That's what we got.
All righty, thank you.
See you then.
I've also got Dre Grinter, if Ms. Gardner wants to take him up, he's in the office.
We can do that. I believe we already have a trial date scheduled for July.
Right, we do.
Okay.
I guess we just leave that on.
I mean, it's staying on unless one of y'all tells me different.
All
Okay.
right.
All right, so there should be a pretrial on June 14th. No, wait a minute.
It says June the 14th on CourtNet Judge.
Yeah. The order that set this trial has 2020 on it instead of 2021. But you guys all understood that to be 2021. Because the order was entered in October of 2020, so we wouldn't have set a trial for July of 2020. So the pretrial is 14 June 2021, and the trial is the week of 20 through 23, July 2021. All right,
Yes, sir.
thank you.
March 74, pretty quick, okay. First thing it broke. Judge, I have Warren County and Edmonson County. And the rest of mine are 3 are jail docket. Would it be all right if I sign back on here in just a few minutes?
Yes,
Thank you.
I've got the paperwork on Mr. Williams, so let's do Mr. Williams, and then that way I can get that facility on.
Is James Rice in jail, Judge? Because that was Johnny's. I have him on the docket. I didn't think he was in custody.
I don't know.
I'll check.
All right. Josh, are you on here?
Yes.
All right. We're going to do Mr. Williams, okay?
Okay.
All right. Mr. Williams, can you raise your right hand for me, please?
Yes, sir.
Do you swear or affirm you'll tell me the truth, so help you God?
Yes, sir.
All right, thank you. I don't know how well you're going to be able to see me, but I'm going to show you. This is a motion to enter a guilty plea. It's got your name on it right there. You see it?
Yes, sir.
Okay. And on the second page, it's got a signature. Is that your signature?
Yes, Your Honor.
Okay. Did you in fact sign this motion to enter a guilty plea?
Yes, Your Honor.
Okay. And did you read through it and discuss it with your attorney before you signed it?
Yes, Your Honor. We spoke over the phone about it.
Okay, good deal. You happen to remember when that was?
It's been a few weeks.
Yeah.
Okay. Because I'm talking to him about this here in open court, I'm going to put today's date on that plea, even though I know that because he's acknowledging to me that he signed it. He's acknowledging today that he signed it. Okay.
Right.
All right. Mr. Williams, I also have from the Commonwealth a offer on a plea of guilty, and that is right here. Does that look familiar to you also?
Yes, Your Honor.
Got your name and case number on it. And again, it's got a signature right here. Do you see that?
Yes, sir.
Is that your signature?
Yes, sir.
All right. Mr. Gardner, are you on here?
I am, Judge.
All right. This, your signature line is blank. Do you authorize me to just put your signature on here?
I do, Judge.
Oh, what happened to your paperwork?
All right, very good. Mr. Williams, again, did you go over that and talk to your attorney about it before you signed it?
Yes, Your Honor. I believe, can I talk to him real quick on here?
Yes.
It was a year run consecutive, wasn't it?
Yes.
Yes, Your Honor.
All right. And Mr. Spears, I will ask you, as an officer of the court, your signature lines on the motion to enter a guilty plea and on the waiver of right to be present in person. One of them is not dated and one of them is not signed. Do you authorize me to just go ahead and put your names on there?
That's fine.
Do you confirm that you discussed with these things with him?
I have.
Okay. All right, very good. I just don't want to hang us up if we can go ahead and move on with it.
Yeah, I
All right,
understand.
Mr. Williams, you understand that you have the right not to incriminate yourself, and you waive that if you plead guilty.
Yes, Your Honor.
You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can confront and cross-examine the people that give evidence against you, and you can put evidence on in your own defense. You can also appeal the outcome of the proceedings. Do you understand that you waive those rights if you plead guilty?
Yes, Your Honor.
Very good. Do you feel like you're under the influence of anything today?
No, Your Honor.
Do you feel like your judgment is impaired for any reason today?
No, sir.
All right, Mr. Williams, the Commonwealth appears to be making the following offer, and I think you already understand it because you just said it, but I'm going to go through it with you. Count one, receiving stolen property, $500 or more. That is a Class D felony. On a plea of guilty, the Commonwealth would recommend a sentence of 1 year to run consecutive to any current case that you're serving, and the Commonwealth would oppose probation. Is that what you believe the offer to be?
Yes, Your Honor.
All right. Other than the Commonwealth's promise to make that recommendation to me, has anyone promised you anything to try to get you to plead guilty?
No, Your Honor.
Has anyone threatened you to try to make you plead guilty against your will?
No, Your Honor.
Are you acknowledging to me that on September the 30th, 2019 in Barron County, Kentucky, you received, retained, or disposed of movable property of another, being air compressors and various other miscellaneous items and tools, valued at $500 or more, but less than $10,000, knowing that they were stolen or having reason to believe that they had been stolen?
Yes, Your Honor.
Okay. Do you know whether, I will accept your plea now. Do you know whether you want to be sentenced today or be sentenced after a PSI that we would do?
I would rather be sentenced today, I guess. If that's all right with you, all of you guys.
That is fine. All right. So, Mr. Williams, I'll accept your plea of guilty to receiving stolen property, 500 more, enter a judgment accordingly. I will accept your waiver of a pre-sentence investigation, and I will go ahead and sentence you today to the agreed upon 1 year. The 1 year will run consecutive to any current sentence. There is also restitution in the amount of $2,993.50. It's joint and several with the co-defendant. Obviously, you're not going to be paying that right now while you are in custody, but you'll need to start paying that when you get out. And even if you serve out or you get parole, any of those things, the restitution does not go away. So until you pay it, okay?
Yes, Your Honor.
All right. So once you do get out, you can start paying a minimum of $50 a month. I usually give you 60 days after you get out so that you have time to try to get a job and all that stuff. Okay.
All right.
All right. Do you have any questions?
No, sir.
All right, Mr. Williams, then we will go ahead and wrap up, and I wish you good luck. Okay.
Thank you, Your Honor.
All right. Thank you.
Thank you, Josh.
No problem.
Judge, I had neglected to tell you, talked with Steve Thornton today on Kevin Hartman. He's the one that had the bike accident and is still, I believe, in poor health. We've agreed to pass that to June 21st. Mr. Thornton wasn't able to appear because he had a scheduling conflict. So if we could just put it on June 21st at 1.
All right. All right, hold on a minute and I'll grab that. and do it. All right,
Okay.
what's next?
Philip Kirby's on, Judge. He's in Powell County. And I think Greg is his attorney. Did we already continue that?
We did.
Okay.
It was probably May 3rd. That's when all the other ones got continued. I didn't see him on here. Which one is he?
I don't know if he is on here.
Oh, okay.
It was the Powell County Detention Center is where he's located now,
Yeah, you
according to
just
Bond.
saying, yeah, I got you. Yeah.
And then Eric Denton is on, but I know that he's in treatment now. I don't know if he's on.
She's just saying it's on the docket. Eric Denton is in treatment. Is that what you said?
Yes.
All right. What about old Dusty Whitlow up there? He was the first guy I had in my meeting. Anybody want to talk about him?
Judge, I think that Ken represents him and he's not on here. I haven't heard from Ken this week either.
I've been texting with him on Dina Richardson. She's on the docket. So he knows that she's on this afternoon. And he also has Trey Williams. I'll send him a text and see when he's getting on.
All right. Well, we'll just have to come back to Dusty then. Okay. All right. All right. Tell you what, y'all give me a minute while everybody's tracking people down.
You work the hall or the kitchen? They come and got you from the kitchen?
Really? Wonder how they got in. All right, I've got my jail folks. I'm just gonna start running down through them in a more or less alphabetical order with some variations. That's what I'm gonna check. Bonnie, is Eric Denton there, or is he in a facility somewheres?
He's here.
Okay.
I thought he had bonded out to go to that treatment program.
Yes, we did bond out.
I thought he had too.
Yeah, we weren't sure. We all thought that, I think.
Some surety bonds to go to rehab would be great, Judge A.
Well, you have surety bonds.
Yeah.
Do you not? Oh, yeah, well, 10%.
You froze up right there, Judge.
I changed your bond on March the 30th.
Yeah, to 10%?
Yeah. So that didn't get the job done?
No. Been here for 3 weeks ever since. 3 months in January total.
Well.
But I've got a bid date and a bid letter, everything set up, ready to go. If I could get surety bonds or RORs or something.
Yeah, I knew that. Go ahead.
I was just going to say, Judge, with his charges, I wouldn't be fine with an ROR. I mean, 10%, what is his current bond now? Is it?
Well,
it's like 2,500.
Yeah, I think two of them would have, the 10% on two of them would have been 500 apiece, and the 10% on one of them would have been 1,000. So it would have taken 2,000 to get out, I think.
I wouldn't have an objection to you, maybe doing a surety on two of them, and then on one of them, if he can put up some security. I just think with the number of cases.
Yeah, I see what you're saying.
I mean, it's a year-long program, Judge. I ain't gonna get out and go to the streets.
Well, I certainly don't want this to be, I mean, I don't think that it's necessarily gonna be your situation, but I have had people that I let out to go to rehab and they didn't do what they got out for.
Yeah. I've never had that opportunity, though. I really appreciate the first one.
Yeah. Can I ask you a question? I'm not sure. Give me just a minute here, Mr. Denton. I'm trying to get. Okay. Well, it's changed in here as being correct, but the order, the bond order in this case, got put in there. But on the calendar, it isn't. Like, in other words, it's changed to what I changed this bond to. See what I'm saying? When I look at the docket sheet, calendar sheet. Oh, it's just that other thing's on top of it.
It's 2 pages.
Oh. Yeah, I knew you knew about it. I just was wanting us to track down the order and get it, but because I didn't realize something had been filed on top of it. Since they were filed on the same. Yeah. All right. Where is it that your bed date is? Remind me.
It's in Williamsburg at Anchored Ministries.
Say again.
Williamsburg and Anchored Ministries.
How were you proposing that you were going to get there?
My mother.
And when did that bed letter expire?
I don't know. My dad said he's been in contact with them for 2 weeks. Have they contacted you? He said, the lady said they talked to you.
Well, they didn't talk to me. They sent me a letter. They faxed me, I think it was a copy of the letter. But for some reason, it's not in your file, and it may just be that I read it and then didn't put it in the file, but I definitely read it, and I knew that they did confirm that they had a bed date for you.
Yeah, I think Mr. Spears has got a copy of it.
Yeah, I believe I sent you after his last court date. I sent you a letter. That was the letter I sent you to as well. I don't remember it having an actual bed date. I think they were going to schedule one for him once he had the bond situation straightened out or something. I can't remember off the top of my head though.
Yeah. Well, I was thinking that they said that he had a bed any day from one point to another point. I didn't want to do something stupid and have that expired, and then why don't we do this, Josh? If you can scrape that letter up, get it to me, and I'll do something on this. I'm just going to be honest. I thought that he had made the bonds and got out. And that was when I set them, and I agree they're 10%, so they weren't just flat out, sureties. But I don't know what made me think that, but I thought that. I think Risa thought that too. I don't know why we both thought it, but if you'll get me that letter so that I can just make sure that I'm not doing something that's going to come back and haunt him, I'm gonna work on this bond deal to where we can make this, try to make this happen. Okay.
My daddy talked to him last night. They said they had a bed ready for me. If we just get the bond situation straightened out.
I want to see something from the place. Okay.
Okay.
Not that I don't trust you or your dad, either one, but I like to lay my eyes on it.
I just forwarded you the last letter I received from them on the 26th. I sent it to you and to Chrissy.
All right. Then I'll look at it when we get a minute, and we'll work on something. Okay. In the meantime, let me just put this pretrial off for a little while. I don't know. Obviously, I'm not going to put it off for more than a year, but I'll put it off for 2 or 3 months. And Mr. Denton, if you're in rehab, you need to stay in contact with your lawyer, and that way he'll know where you are. And we won't be running off half-cocked and doing something to you that we're not supposed to do. Okay.
Can I put my mother down as a surety? Is that what the bond's going to be, you think, or are you going to leave one of them at 10%? Or?
I'm not real sure yet, but I'll use your mother as a surety. What, you want to tell me her name?
Selena, Selena.
Yeah, that's right. You told me that the last time.
Yeah.
All right. Let's Josh, let's put his pretrial out to, let's call it July the 19th. And then you all just keep me in the loop if he's going to be still in treatment and not able to travel or anything like that. I mean, we can probably, we'll probably still be doing jails by Zoom. So we may be able to do somebody that's that far away, by Zoom as well.
Okay. I will say this, Judge Zanda or Greg will be taking this case over 1st of May. So I won't be on it after the 1st of May, but I'll keep them both in the loop till then.
All right. Thank you. All right, Mr. Denton, we'll get to work.
So I might know something about bond by the end of the day?
Yeah, well, it won't be today because I'll be sitting here doing this stuff all day, but it'll be tomorrow.
All right, thank you.
All right.
All right, thank you.
Yeah. She signed his last bond, so her name is in there. Thomas Dobson. I was going to say, did we move those? I thought those were created. All right, Mr. Spears.
Judge, his cases have now been transferred to Zanda. It got transferred out of my name, so I'm no longer his attorney.
Oh, okay.
And bear with Ms. Myers. She literally just got these cases mid last week, so she probably is not very familiar.
Yeah, Judge, I haven't had a chance to go through his file just yet and update myself on everything. Is there any way we can set this over for 2 weeks and I will get through his file and be able to talk to him and actually meet with him in person?
Sure. I think he might have at least one of these set for trial. Am I wrong?
Judge, yeah, the one endangerment case is set for trial sometime in, I want to, I think May, or it was in May, but I figured we'd be probably end up continuing it anyways.
The 15th. He's already got a pretrial on for May the 3rd, so I can just put it on for May the 3rd.
That'd be fine, Your Honor.
All right. I mean, we had taken it off and moved it to today because he was going to be in custody, but I'll move it back.
What's the trial date that's currently scheduled for it?
I think it's May
15th.
I was going to say, I think it's somewhere in that no, it's somewhere in that like 18th, 19th, 20th, somewhere in that ballpark.
Yeah.
John, is it scheduled the same time as the Carter case is?
Yeah.
Okay.
Judge, I think he was one of those that we kind of scheduled a bunch in that same time frame just to kind of see where we'd be and if they would go or not. So if I remember right.
Yeah. No, I think you're correct. So let's we'll go back to Monday, May 3rd at 1 o'clock.
Thank you, Your Honor.
Excuse me, Your Honor, is there any way that I can get you to set my bond for security so I can get out today?
Mr. Dobson, I don't plan on doing that today.
All right, thank you, sir.
Bet. Let's see. So some of these I know are probably Greg's. I can't remember which are which. Is James Brandon Keaton, was that one of Greg's?
Yes, sir.
So we had to move that to May 3rd, right?
Yes, sir.
All right. Colby Hamilton,
That's me, Your Honor.
is that you? Okay.
Yes.
All right. Ms. Myers, where are we here?
Your Honor, I've received discovery from the Commonwealth as well as an initial offer. I've also had an opportunity to meet with Mr. Hamilton. Right now, he actually has a motion for shock probation that is pending over in Monroe County. Before we make a counter offer, we'd kind of like to see what happens with his motion for shock probation over there. So I was going to request a second pretrial conference in the case.
That's not a problem. What idea, do you have an idea about the date?
It looks like the motion for shock was filed March 30th. I'm thinking that there should be some decision in May. So I was going to suggest to the court maybe May 17th for a pretrial conference.
All right, that's fine.
Judge, just to chime in, to be on the safe side, I'd probably go a week later because I can't remember. I'm thinking start down there. It's the 19th that month, or it's past that court date. So
Yeah, what do they do?
Next week.
Do they still do third Wednesday?
Third Thursday.
Thursday.
Yeah. And I'm thinking third Thursday is like the 20th.
20th, yeah.
So I'd probably go to that next week.
All right, so May 24th.
That'd be fun.
All right, thank you.
Thank you.
Matthew Kingery. Oh, does Ken Garrett represent you?
Yep.
Okay. Just have a seat if you don't care. We're waiting on him to get in.
All right.
Cody Slaughter.
Your Honor, oh, he's here. I've sent an offer in this case. I haven't received any kind of response.
Judge, I spoke to Mr. Slaughter today. He has a he's currently serving a 10-year sentence in the Barron County Jail, and his serve-out date is July 1. He did not give me a counteroffer at this time. He was asking that this be continued into July, or he might be willing to take a deal at that time, but he said he's willing to continue to July, to like middle of July if possible.
That ain't gonna be that far away.
And by that time, this case will be handed to Ms. Myers.
You want to look at July the 12th?
Your Honor, I think I'm supposed to be out July 11th through the 24th. That's right. I'm trying to look at my calendar real quick. That's for, yeah, that's for continuing education.
They want them to be smarter than they want us to be, which is not hard. Yeah, well, so you tell me then what works for you.
This is, I'm sorry to interrupt you. It is it's a possession case, presumptive probation. So I don't know if it's something we could take care of sooner rather than later.
The offer was 2 to serve, so it wasn't.
I think that's when I thought he was a state inmate, like going to be for longer.
Yeah.
Okay.
Maybe
it sounds like he's a state inmate for the next 3 months at most, it sounds like.
Yeah.
Can we just set it for April 26th? I know that's a week, but I can get down to the jail and meet him this week and see if he's interested in that offer.
Yeah, I mean, if the offer has changed from 2 years probated to 2 years to serve, he might have a different outlook. All right, let's go 26 April at 1 o'clock.
Thank you.
Thank you.
Judge, I'll add as well, if I may, for Mr. Slaughter, it looks to me like the parole board gave him a serve out, and that his minimum expiration is April the 2nd of 2022. I'm not sure if they're wanting to give him MRS or something in July or what the date is, but.
Yes, sir. I hit MRS July 1st.
Okay.
All right. Cody, we'll see you next week, okay?
All right. Thank you.
Jacob Williams.
Judge, we've hit a stalemate on this case. I'm just going to ask that it be there's his grandmother called me. I need to call her back and talk to her about this, see if there's anything she can bring to the table on this. I don't know if it's going to affect anything, but I would suggest let's put this on May 3rd, and then whoever takes over this case from me, I'll get the information to them.
That will be Greg.
Okay. I'll keep Greg in the loop.
Is that it?
Yep.
So what is Joshua Spears not gonna be my attorney anymore?
No.
Well, sounds like not if something doesn't get worked out in the next couple of weeks.
All right, that'd be all right. Thank you.
All right.
Judge, I'm sorry, what was that date again?
May 3rd,
Okay, thank you.
AKA the day that none of us will go home. I'll go get up. I'll go. I don't care. Can't do it without me. All right. I think most everybody else I have down there, I think Mr. Bell's involved, or they've asked me to do it at the end. It's possible that we could.
There's Amanda Nichols, Judge. I think Bruce Brown has her.
Oh, she's not on my jail list here.
Well,
Ms. Cord, Your Honor, should be at the jail as well.
I think they've asked to put her at the end, Greg.
Okay, I'm sorry, I didn't hear that.
So Amanda Nichols?
She's in jail?
Is she in our jail?
Don't have her, Judge.
He was out last time we appeared.
That's why I've forgotten that she was out. 'Cause I remember she appeared by and she was in a car last time.
Anybody heard anything from her?
I have not.
Well, that ain't good. I believe that she got these court dates
I
personally.
do have a number for her. I will try her.
Yeah, if you can figure out a way to get her on here before I finish up, I'll hold off.
I remember, I mean, she was in a car last time, you know, we had Zoom court, or she was appeared by Zoom court, because I remember myself and then Micah said something to Will that she appeared under the influence.
Well,
that's
Went straight to voicemail.
Your lawyer, no. Your lawyer.
Joshua Spears.
Not sure anybody would do that.
Got it.
Heard of. All right. Let's see. What about any of these folks that we've got that aren't in custody that are on our call here? Is there any of them we can deal with?
Judge Etta Lutterman has been on to enter a rocket docket plea. I see her sealing. I've seen her face occasionally.
Well, if we have her sealing, she's probably not far behind.
Yeah.
There she is. Miss Luderman, can you turn your mic on?
Unmute. Now, is it on?
You better believe it.
Okay, on.
All right. Am I supposed to have paperwork on this? Ms. Gardner, I don't have anything on it.
Okay, well, I believe it's been on for a while. I can email it to you right now, or do you want me to email it to Chrissy?
Yeah, it'd be better to email it to Chrissy and then she can print it and send it in,
Okay,
please.
I'm
Ms.
sending
Ludeman,
it right now.
We'll come back to you, okay? Sorry, it'll be a second.
Okay, hon.
Judge, I see Terry Carroll is on, and I know that I believe Josh was representing her.
Judge, we got no resolution in this case. I've yet to make contact with her. I have not even spoken to her yet or been able to go over discovery with her. So I guess we'll just have to pass this a couple of weeks and then whoever, I guess Greg or Xander will take it over. That's all I can really say.
Terry, you on there?
She was a minute ago and then
Hello, can
There you are.
in the refrigerator.
you have to, I don't know how to turn it around.
I tell you, this avant-garde filming style you're employing is making me nervous.
I do not know how to do this.
Well,
Hold on.
yeah.
Can you see me now?
Yes.
Yeah, that was a bro. All right, look, keep it still. Can you prop it up against something?
I'm holding it. I gotta turn around backwards. I don't know how to turn my camera around. I can't get to the screen.
All right. Can you just prop it up against something where it's not shaking? Oh, look at that. Look at that. All right. Terry, here's what needs to happen. I need to put you together with your lawyer so you all can talk because he says y'all haven't talked.
Right. I've moved and I've been working every day. And
Well, look, I'm not griping at you. I'm just wanting to know, how do we want to do this, Mr. Spears? You want to give her a number or get a number or what do you want to do?
Let me just get her number. Let me just get her number and I'll call her later. I'll call her later this week and I can get the preliminary information to pass on to whoever gets this case.
This will be going to Xanda and she is on here, so.
Okay, so that works.
Terry, give us the number to that little device that you're.
270-390-7430.
Ms. Carroll, do you get text messaging on that number too?
Yes, ma'am.
Okay, I'll send you a text message with my direct number, okay?
All right. Thank you.
All right. Mr. Myers, how long do you want me? You want to try May 17th for this one?
I might be able to talk to her this week, actually, if you want us to try to just set it over a week and I'll see if I can get it squared away in a week.
Oh, yeah. Well, if you think you can do that, that's all the better.
If she responds to my text, then we'll keep it moving.
Terry, when she texts you, you need to text her back, all right?
Yes, sir.
Okay.
Hey, Xanda, I'll put the file on your desk.
Thank you.
All right. So Terry, we'll jump back on here next Monday at the same time, okay?
Yes, sir.
All right. You have any questions?
Yes, sir.
Keep your eyes peeled for that text so that you can talk to your lawyer, all right?
Yes, sir.
All right, you're good to go. Thanks.
Have a good day.
That just gets me every time, man. The phone flipping all around. All right, Miss Luderman, are you back on there? I've got your papers now.
Yes.
Good deal. Okay. Can you raise your right hand where you are?
Yes.
Do you swear to tell me the truth, so help you God?
Yes.
All right, very good. Let me show you what I have.
Okay. Is Candace there, my lawyer?
Candace is not with us right now.
Okay.
Do you need to ask a question of your lawyer?
No, I didn't know if she had to be there or not,
Before we go any further, Risa, I don't have a motion to enter a guilty plea. I just have an offer.
Now, I'm supposed to be back in court, I think, one day this week. The
That's just
22nd.
for a review in district court.
Oh.
I thought I sent that. I'm sorry, Judge. Let me see if,
Let's check and see if you have that before.
I do.
Oh, wait, it's coming. All right, yeah, here it is. Okay. Oh, yeah, because the pretrial diversion also, right?
Yes.
Order, okay, cool. All right, Mr. Ludeman, so I've sworn you in, right?
Yes, sir.
Okay. What I want to do is look at some of these things with you and, you know, find out whether you have seen these things before and you understand what you're doing. That's the purpose of this hearing, all right? So
Okay.
the first thing is, this is a document that is called motion to enter a guilty plea, all right?
Yes.
Does that look familiar to you?
Yes.
All right. And on the back page, there is, on the signature line, that's clearly not your signature, but it's, you know,
I gave
kind of
I gave Candace permission.
that's what I was gonna ask you. You jumped ahead
Yes.
on me. Good deal. You've
Yes,
been listening, hadn't you? All right.
Yes, sir.
Yeah, very good. All right. There is the Commonwealth's offer on a plea of guilty. It's got your name on it. Same kind of deal.
Yes.
On the second page, I think maybe on this page, it does not have your signature on it, but did you intend to have her put your signature on this page too?
Okay, and what's that page?
This is this would be your acceptance of the offer. The
Right.
offer is to give you a 1 year sentence. I mean, I'm summarizing. We'll go through the details in a minute, but 1 year sentence, pretrial diversion for 2 years.
Yes.
All right. So you intended to have her put your name on that as well?
Yes, Candace was supposed to sign them papers for me.
Okay. Do I have your approval to just go ahead and write your name on there and say that it's per your authority?
Yes, sir.
Thank you, ma'am.
Thank
All
you.
right. And so here's what I need to ask you now. You understand that nobody can force you to enter a plea of guilty. And if you do so, that has to be a decision that you reach without feeling like somebody else is making you do it.
Right.
All right. Do you feel like either myself or anyone else is forcing you to enter a guilty plea today?
No, sir.
You understand that you have the right not to say anything that could incriminate you, and you waive that right if you plead guilty.
Yes, sir.
You understand that you have the right to have a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. You waive that right if you plead guilty.
Yes, sir.
Okay. You understand that you waive the rights to confront and cross-examine people that give evidence against you and to put evidence on in your own defense if you plead guilty.
Yes, sir.
You understand that you waive all rights of appeal by pleading guilty.
Yes, sir.
All right. Ms. Ludeman, do you feel like you are under the influence of, do you feel like you were under the influence at any time that you were either reviewing these documents or today when you and I are discussing them?
No, sir.
Wait, all right, Ms. Ludeman, in your offer from the Commonwealth, it's they recommend as follows. If you plead guilty to count 1, possession of a controlled substance, first degree, that is a D felony. The Commonwealth recommends 1 year. Possession of drug paraphernalia, the Commonwealth recommends 12 months. Those run concurrently or at the same time for a total recommended sentence of 1 year. The Commonwealth would agree to supervised pretrial diversion for a period of 2 years. What that means is that you would not be sentenced, but you would report to a probation and parole officer they, at their discretion, would get you assessed to see if you had any substance abuse issues that needed to be addressed as part of your pretrial diversion. You would report to them and kind of do what they said. You'd have to tell them where you're living and, not leave the state without permission, things like that.
Right.
But at the conclusion of that period, if you have successfully done everything that you are supposed to do, then your charges actually get dismissed. So you don't have a felony on your record or anything else at all gets dismissed. Okay.
Yes.
Is that kind of how you had it explained to you?
Yes, sir.
All right. Is that what you have agreed to?
Yes, sir.
Are you, Ms. Luderman, acknowledging to me that on January the 14th, 2021 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes.
Okay. I'm going to accept your plea of guilty. And now I'm going to look at this pretrial diversion order. And this is kind of the last thing I need to talk to you about. Again, it's got all of this on it, your name and your case number and all that, the terms that you've agreed to. And if I go over here to the back page, it's got your, your virtual signature or whatever on there. Okay.
Yes, sir.
So do you feel like you authorized Ms. Hill to sign your name to that as well?
Yes, sir, I did.
All right, good deal. Here's what we're going to do. I'm going to sign off on this, get it entered today, and your pretrial diversion can just go ahead and start, okay?
Okay.
Can you tell me what your address is? Because we tried to send you a letter and it came back.
Okay, it's 2021 ONE Tree Lane, Glasgow, Kentucky.
202 One Tree Lane.
Yes, sir.
I got you.
Thank you.
All right. Ms. Luderman, I'm going to enter this pretrial diversion. You'll have court costs that go with your pretrial diversion. It's $165. All right. And I'm going to give you 6 months to pay that.
Okay.
That's really the only, you're not going to get a fine or any of that other stuff that goes along with it.
Okay.
So
thank you.
That'll just be the one thing that I'm going to need you to take care of. And we have a probation officer on here right now. It's Officer Bennett. You may see him right there. He's going to tell you what your reporting instructions are. Okay.
Okay, hon. Thank you.
You bet. Officer Bennett, go ahead.
Ms. Litterman, we need you to report to the office in the morning for your basic stuff. All your intake information will be taken care of at that time. Do you know where our building is?
No, sir.
Okay. Do you have something that you could write our address on?
Yes, sir, I do.
Okay. It is 100B Reynolds Road.
Okay, I think I know where you are now. Yeah, because I think I brought my brother down there one time.
Okay, well, good.
Okay.
Yeah, just 8:30 in the morning, and we'll get you taken care of. Okay.
Okay, hon.
Thank you.
Thank you. 8:30.
All right, Miss Luderman. Thank you.
Thank you, hon. Leave.
Here, just hold tight. I'll let you. I'll get you out. Okay.
Okay, because I don't know.
No, here you go. See you later. All right. Did I see Ken come on here?
I'm here, Judge.
Ken, you got a few. Who do you want to talk about?
Judge, I've got Dina Jo Richardson.
Yeah, she with you?
She is on the line, I think. Let me double check. If not, we can call Dusty Whitlow. He should be on the line.
He's on there.
And I'll get Dina on, Jody Richardson on the phone.
Who is 282-9008? Yeah. I don't know either. All right, Dusty.
Yes, sir.
Judge, I think we have got this case resolved. The Commonwealth has sent us a very reasonable plea offer. There is one other detail that I need to speak to Mr. Gardner about. If we could have just 1 week, this case is going to resolve. I'm 95% sure of it, but there is one detail that I just need to speak with Mr. Gardner about.
So you want to go to the 26th?
Yes, Your Honor.
That work for Dusty?
Yes, sir.
Yes, Your Honor.
All right. 4/26 at 1 o'clock.
All right, thank you.
Yeah, Ken, any special instructions like for him to call you or anything?
Judge, I will get in touch with him after I speak with Mr. Gardner just to resolve that other detail.
Thank you.
And Judge, I'm trying to reach out to Miss Richardson about getting on the call. So if you can give me about 3 or 4 minutes, I'll jump back on and let you know.
All right, that's fine.
We good here?
Yeah, you're good to go.
Dusty, you
All
can
right,
hang
thank
up.
All right, thank you.
All right. I guess I don't know what else we're ready to do, but if anybody knows something, I'll do it.
We're ready on Samuel Brown.
Okay.
All right.
Well, we can do Crystal Crockett next, Bruce.
Samuel Brown.
Judge, I've received a counter offer today that I'd like some time to consider. If it's okay, if we could put it to the first Monday in June at 1 o'clock.
Ms. Myers, is this you?
It is. I apologize.
No, that's fine.
Yes, I extended a counter offer and we've spoke about setting it over to the first Monday in June. That would be fine, Your Honor.
All right, good deal. June the 7th, 1 o'clock. And then hopefully, well, if there's something worked out, everybody's paperwork will all be lined up. We can get that taken care of. Mr. Brown, all other things being equal, we'll be meeting in person at that point in time. So we'll see you up here live, okay?
I'm sorry, when was that?
Oh, I'm talking to a different Mr. Brown.
Oh.
I'm sorry. I'm talking to Samuel Brown.
Okay. I was
All right.
confused.
All right. Thank you. Dana Richardson. Oh Lord, she's got a plea in her. All right, Bruce, what'd you want to do?
Crystal Crockett, I see her name on here. I need to ask for another date. I need to be able to meet with Miss Crockett. The Commonwealth has tendered an offer to me, but I haven't had a chance to meet with Miss Crockett yet.
Miss Crockett, are you there?
Yes, sir, I'm here.
Does your camera work?
I think it's there. There we go. Did it come on? It should be coming up. It's just showing me a person. I don't know why it's not coming up on my camera.
All I'm getting is your name.
I'm not sure why it's not working. I can see everybody else, but I can't see myself either.
Okay. Mr. Brown, did you have a specific day in mind?
No, I mean, can I get a good number for you, Crystal?
Yes, sir. It's 270-336-3542.
Okay, do you have something to write down with? Can you take down my number and please call and make an appointment with my paralegal?
Yes, I've got it ready.
Okay, it's 270-651-9000.
Okay.
I guess I just asked for 2 or 3 weeks to have a chance to meet with her and discuss the offer and the discovery.
Let's do May 10th, okay?
Okay.
1 o'clock. We'll be meeting in person at that point unless something strange happens. So I will expect to see everybody up here in court, okay?
Yes, sir.
All right. Do you have any
All right.
questions?
No, I
That
think I've
works.
got everything.
Just
All right.
call, when you get off here, Crystal, call my office and make an appointment to come in and meet with me, okay?
Yes, sir. I'll call right now.
Okay.
All right. Thank
Thank
you. All right. Let's see. Did Miss Richardson come on?
Judge, I'm waiting on her. I'm trying to, she's having some trouble, but I'm sending her another link.
Just down here.
She tells me she's on, Judge. There she is.
All right.
And Your Honor, before we start, I had sent Ken an offer this afternoon with the incorrect restitution amount. I just want to make sure the one he provided the court had the correct amount.
I think it was 141.
Okay, that's it.
All right. Say again now. What amount are you?
It's on there is $141,104.63. And I believe that's to be reduced by a $50,000 insurance payment. I just need to double check with Techno.
Because I don't have either one of those numbers. I have 139,970 something.
That's wrong.
Did you get the fax that I sent, Judge?
This is the fax that I got.
It says 139.
Listen, I'm blinded about it. What does it say?
Your Honor, the confusion is there were a couple different numbers that were provided in discovery. That was the initial number that when we put the offer together, I thought that was, and after talking with Techno, it's $141,104.63. And I did a corrected offer and sent that to Ken shortly after I sent this one.
I'm just trying to prove to y'all that I'm not crazy. See that number?
Oh, it is 139. Well, Judge, I would agree that whatever the correct number is should be on there. If that is not, we can send an amendment with regard to the correct amount of restitution.
Well, I mean, if you'll tell me the correct number right now, which I wasn't clear if you meant the 50 had already come off or what. If you'll tell me the correct number right now, if you know it, then I'll write it in here and then I'll go over it with everybody on the record.
Judge, I don't think we know it because Ms. Gardner needs to check to see what the deduction was from the insurance payment paid to Tech.
Okay.
But without insurance, without anything being taken off, the correct number is $141,104.63.
All right. Well, that's a number to start with. And then we'll talk about the possibility of the offset and everything like that when we get on here. Okay. All right. So, Ken, are you and Miss Richardson, are you ready?
Yes, Your Honor.
All right. Miss Richardson, can you raise your right hand? Do you swear to tell me the truth? So help you God.
Yes, I do.
All right. Thank you. Ms. Richardson, I want to make sure that you can see these things that we're all talking about. If you were standing here in front of me, I would just be handing them to you and letting you look at them. But since you're not, we'll have to do it this way. This is a document that is entitled Motion to Enter a Guilty Plea. You see that?
Yes.
And it's got your name and your case number on it. On the second page, it has a signature line. Is that your signature?
Yes.
All right. Commonwealth has made an offer in writing. That's this document here. You see that?
Yes, I do.
I let it fall down.
Yes,
And-
sir.
All right. And there's a signature on here as well. Is that your signature?
Yes, it is.
Okay. Did you go over both of these things thoroughly before you signed them?
Yes, I did.
Did you have all the time you needed to discuss them with your attorney?
Yes.
All right. Do you feel like you made sure that you understood what you were signing before you signed it?
Yes.
All right. Do you realize that you have the right not to incriminate yourself? And if you plead guilty, that has, then that is incriminating yourself. So that is a waiver of that right. You understand?
I do.
All right. You understand that you have the right to have a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. If you plead guilty, you waive that right.
Yes, sir.
Okay. You understand that you have the right to confront and cross-examine the people that give evidence against you, as well as the right to put evidence on in your own defense. If you plead guilty, you waive those rights.
Yes, I understand.
All right. Do you understand that you have a right of appeal? And if you plead guilty, you waive that right.
Yes.
All right. Thank you. Ms. Richardson, do you feel like you are under the influence of anything today?
No, sir.
Do you feel like your judgment is impaired for any reason today?
No.
All right. In this case, Commonwealth has made the following offer, and this is the part that, you know, we need to make sure that we all understand this in the same fashion. You have one count of theft by unlawful taking, $10,000 or more, but less than $1 million. That is a Class C felony charge. The Commonwealth has agreed to make the following recommendation on your plea of guilty to that charge. The Commonwealth would recommend a 7-year sentence plus a possible fine and court costs. The 7-year sentence would be, let's see, the Commonwealth would not oppose probation of that 7-year sentence. After service of an alternative sentence of 180 days, probation would last for 5 years or until restitution is paid, if it takes longer than 5 years. And the restitution amount, as we sit here today, is $141,104.63. But everybody agrees, the Commonwealth agrees, that that amount is likely to be reduced by some insurance payment, which they're going to inquire about, and then we can always come in and amend that amount, you know, once we find out what the actual dollar figure ought to be. Okay.
Okay.
All right. So on your offer sheet, what I did was, you know, we had that number 139 something that wasn't right. So I changed it to the number that I just told you. Do you understand that?
Yes, I do.
All right. And I'm gonna make one more change, and that is subject to a possible reduction due to insurance. So I wrote that, and I just want everybody to see that, so that I hope you can read that. I don't know how clear it looks on that screen, but
Yes, I can read that.
all right, all right. So that is the offer from the Commonwealth. And is that what you understood the offer from the Commonwealth to be?
Yes.
Other than the Commonwealth's promise to make those recommendations to me, has anybody promised you anything to try to get you to plead guilty?
No.
Has anybody threatened you to try to make you plead guilty against your will?
No.
Do you feel like I am making you plead guilty?
No.
All right. Ms. Richardson, are you acknowledging voluntarily and of your own free will here today that between November 29th, 2017 and October 23rd, 2019 in Barron County, Kentucky, you unlawfully took or exercised control over movable property belonging to another person, namely money belonging to Techno Incorporated, value of $10,000 or more, but less than $1 million, with the intent to deprive the lawful owner thereof. That constitutes theft by unlawful taking.
Yes.
All right. All right. Then, Mr. Garrett, I am going to accept Mr. Richardson's plea here to the single charge of theft by unlawful taking, Class C felony level. I'm assuming that you all are going to want a PSI because it seems like maybe there's some things that need to get straightened out, and also that dollar figure, it'd be nice to have that by the time we came back.
Yes, Your Honor.
All right. So I am going to enter a judgment accepting the plea. We will set a sentencing for, do you have a particular time, Ken, that you want to do it? I mean, it needs to be at least 30 days out and probably no more than 60 days out, but it can be anywhere in that window.
Judge, can we just do June 7th, Monday, June 7th?
Yes. Officer Bennett.
I'm here, Your Honor.
All right. This Miss Richardson has entered a plea. She's out of custody, and you know she's asked for her PSI, and we will set her sentencing for June the 7th. So I know that you all have to get a PSI packet and all that stuff. So will you tell her what it is you need her to do?
Yes, Miss Richardson, you will need to call Investigator Frazier. Do you have something you can write a phone number down on?
Give me 1 second, please. Okay, go ahead.
It's 270-282-3128.
Okay.
And she will set you up an appointment to complete that, the PSI packet, and to go further.
Okay.
All right. So, Mr. Garrett, we'll do that at 10 o'clock on the 7th day of June, 2021. Ms. Richardson, you need to call the probation and parole, Ms. Frazier, as soon as you can, tomorrow or whatever, because, if she hadn't heard from you in a couple of days, she's going to consider that to be non-compliant. She'll be telling me, and then I'll have to, shake a tree and see what falls out. So let's go ahead and be sure we do that. Okay.
No problem.
All right. Any questions from anyone?
No, Your Honor.
All right. We're good. Thank you.
Judge.
And we will see you on June the 7th at 10 o'clock.
Thank you.
All right. You're welcome. Okay. Let's see. Who else? Did that take care of all of Ken's cases? Do you have one more?
Judge, I think that should be all of mine.
Oh.
We had Trey Williams, Ken.
Oh, okay. I'm sorry. I didn't have that on my calendar.
I got King too, Ken.
Oh, I knew that. Shoot. It's been a very big Monday.
Don't forget about me.
Yeah, I can we call Matt Kingery, Judge?
Yeah, he didn't forget about you, for heaven's sake.
No, but you was trying to, wasn't you?
Yeah, I had actually just gone to the jail a few minutes before 1 o'clock to see him.
All right, what do y'all have in mind with Mr. Kingery?
Judge, I was gonna, of course, I've just entered this case here within the last probably 3 or 4 weeks. I was gonna ask the case to entertain putting him back out on bond. I don't know if there are any district court cases that are holding him, but Mr. Kingery tells me that one of his bonds was revoked as a result of getting a new charge. And I think that was the 20 CR 146. I don't have my notes, but let me look. Yeah, it was a 20 CR 146, Judge. I believe he was on a 10% bond and the court revoked that bond.
Yeah, I think there was a motion filed, and I believe it ended up here in a little bit of testimony from maybe on two different cases, one about a new stolen property charge and one about a new criminal mischief
Yes.
charge. So two separate instances.
Judge, there were actually two receiving stolen properties that were before either the district court or circuit court, only one of which was indicted. That was 21 CR 88. The other case was an attempted receiving stolen property, which was, I guess, either remanded back to district court or maybe there was just a no indictment on it, but that case was 21 M 135. And so I would ask the court on his 21 CR 88, I don't know if this is actually on for a pretrial today or not, but actually it is. If the court would consider resetting a bond and reinstating the bond on the 20 CR 146, to include, if the court deems necessary, an ankle bracelet. Mr. Kingery does have some dental work that needs to be done, not just cosmetic, but he has a tooth that I think broke in half. He did have I guess probably some infection or an abscess within the last week or two. But this would enable him to get that taken care of and off the county's dime if the court would be inclined to give him a bond.
Who's
Judge, this is my case. Yes, the court did hear testimony and revoked the defendant's bond based upon at least, I think, two charges against Mr. Kingery. I think it was Deputy Roberts testified that attempted was an incorrect charge. It should have been discharged as a receiving case, and that case is still pending, I believe, and needs to be presented to the grand jury. We have presented the other case to the grand jury. Indictment was returned. The Commonwealth has serious concerns if Mr. Kingery is let back out on bond. He's proven that he's unable to comply with the conditions, unable to comport with the laws of the Commonwealth, and had two instances here where he had received what would be felony charges. So based upon that, the Commonwealth is concerned if the court is to grant him a bond, would ask that you make it a fairly significant cash bond to ensure that there was compliance with that. And also, I need to speak with Ken about a possible global resolution to these cases.
Well, yeah, the deal with the one charge was that I think the officer, the deputy, he put that in. It was coded as attempt receiving stolen property, but his testimony, certainly there wasn't anything attempt about it. So I asked him at the hearing, and he said, I did not intend to charge attempt. I intended to charge receiving stolen property. And so that case, I don't think has been amended or remanded or anything like that. I think Mr. Gardner, well, he would know, but I think it's probably still pending in front of the grand jury, or could be presented even as soon as the next time they meet. So I don't think we're out of the woods on that one yet. What I do think it would be worthwhile to let Mr. Gardner and Mr. Garrett talk about, any kinds of possibilities that we might have. I'd be willing to, I think, Ken, you're just, didn't in one of these cases that we talked about today, just have you come back on Monday?
That'd be fine, Judge.
I think we can do that. I think, I know you're just getting your toe in the water here, but there's a lot going on here. And I think that the sooner Mr. Gardner and you can start trying to figure out if there's any path forward, the better off we are. And then, you can bring that up. If y'all don't come up with something, you can bring that up again when I see you on Monday, and I'll look at it. Okay.
Yes, sir. I can do that.
All right.
Is that it?
Yes, sir, it is. We'll go over to April 26th.
Matt, I'll be back up there to see you.
All right.
Got a lot on April 26th, too. I gotta catch that now. A whole bunch of other board meetings. All right, Ken, what we got with, y'all said Trey Williams?
That's correct, Judge.
I didn't have that on my calendar, so I failed to do anything on that for today.
I am not sure. I guess he's not on the call then, right?
He likely, Judge, is not on the call. I guess with court dates being moved around and stuff, that this one is one that just didn't make it to my calendar.
He
But
was set in November, so I think that's why. He was one of
Yeah.
those, the 1st of November. So we weren't in court the last time.
Yeah, I mean, to be fair, they don't usually send these court notices to the lawyers. They send them to the clients with the idea that somebody that is looking at a potential felony that might put him in prison would at some point call his lawyer and chat with him. Apparently that's an assumption that's not founded in fact in my experience. So,
Judge, can we put this on for maybe 2 weeks?
yes. No, let's put it on for 3 weeks,
Okay.
May 10th.
And I'll touch base with him, and then I'll touch base with the prosecution and try to get this worked out.
All right, there we go. All right, Mr. Garrett, that got you covered?
Yes, Your Honor. Thank you so much.
Thank you. All right. Let's see, working my way down through here. Risa, I have a, looks like we have Cayenne Allenspach.
That's correct, Judge.
That is a rocket docket possibly.
Yes, we have that resolved, and Robert had sent the paperwork on Friday, but he had sent the incorrect motion to enter. He sent the DUI guilty plea form rather than the standard form that we use, and I don't believe a new one has been provided to the court. The correct version has been provided.
Yeah, I don't think so either. So do you want to try to, we can either try to do this on Monday, or we can do it 2 Mondays from now and do it in person.
We can do that, or, I mean, even if sometime this week, if there's some time, I don't care to, I'll be at work.
Yeah, I mean, we can do it this week if she's got I mean, if I can feel fairly certain that he's going to get us a updated plea form.
Okay.
Oh yeah, it just got the magical take care of fairies took care of it. No, he needs to take care of it, right?
Yes.
All right. How much time do I need to give him to take care of it? Do you expect?
I would hope by Wednesday, Thursday, or Friday, that's something we could do.
Oh yeah, I would hope so.
I would hope.
I would have hoped by Monday it was something that he would have taken care of. Well, I'll tell you what, let's do Friday morning.
Okay.
At 9 o'clock, just because I've got stuff the other mornings and, you know,
Okay.
nothing that I can't work around if I have to, but we might as well just put it on there.
She's already disappeared, it looks like.
Well,
Oh, I'll talk to Robert and let him know.
Yeah, all right. Friday, the, what's it, 23rd? That's what we'll do.
Judge, I know Bruce Brown's still on here for, I guess Amanda Nichols is the only thing he's got left.
I think he might have, part of the,
Oh, James Depp, that's
James
right.
Depp, and I was waiting
Yes.
for Johnny to get on, but he's on now. So I think we can do Mr. Depp.
Yes, sir, we can.
All right. All right, Mr. Bell, what are you thinking?
Your Honor, Mr. Gardner made us an offer. I went and discussed that with Mr. Depp at the jail. He had I wanted me to do a counter offer. I've made that counter offer to Mr. Gardner, and Mr. Gardner was not willing to accept that counter offer. If Mr. Gardner and the court would permit, I'd like to try to get a hold of James this week and talk to him and see if he wants to take the original offer, or if not, we'll have to just, take things to trial.
All right, when do you want me to put you on for?
Judge, we can do it Monday, or we can do it, I'd like to do it while we're still on Zoom, if there's any way possible.
Well, that'll be Monday then.
All right, that's fine with me, Judge.
Monday, the 26th at 1 o'clock.
Yes, sir.
All right, thanks.
Thank you, Judge.
And then Bruce, did you get in touch with Amanda?
I've not been able to get a hold of Miss Nichols.
Well, good.
For my notes, it did say that she appeared, via Zoom last time.
Is this the, I kind of hate to give people ideas, but is she the one that had some sort of surgery and got an infection in her?
I do think that, yeah, I see that in the previous notes that, yeah, she had a medical issue. I guess I would ask the court if they would let me try to give me a week or two to try to get in touch with her and have her reappear rather than issuing a bench warrant today.
Well, I mean, it was a fairly significant thing. The people, the nurse or medical personnel or whatever that saw her at the jail, they said that she needed to be sent to a specialist, I believe in Louisville is what the deal was. And so I let her go. I let her out to go do all of that because they talked like maybe she was going to have another surgery or something. I guess just to try to be as generous of spirit as I possibly can be, she might have a really, a medical reason that she's not on here. So I'd be willing to try to give you a wide berth on that just to, see where we are. Can I give you till May the 10th?
That'd be fine, Judge.
All right, that's what we'll try to do. Thank you.
Okay, Judge. Thank you. I think that's all I have.
All right, see you later. All right. I think, Johnny, I think all we've got, well, I think we need to talk about Mr. Rivera. And then we've got some other people that are in custody, but they are going to bring them in later.
He also has James Rice.
Oh, yeah. But did we decide whether he was in custody or not?
He's
I
not
can't
in
find him
custody.
anywhere.
He's not in custody.
You know, well, we'll get to him in a minute then. All right. So Mr. Bell, the deal was, and I know I told you that I was gonna
Yes,
get a decision on this. I think Angel called and I hadn't had time to do anything, but I told her what the answer was going to be because with this Class B trafficking felony in the 20 CR 99, I just couldn't get myself to agree to that.
Well, I mean, that's the first I'd heard of that, Judge. I'll ask Angel, but maybe she didn't understand, but we didn't know what had took place. And Judge, Mr. Riviera's case, with all respect to the court, Your Honor, I'm Mr. Riviera's lawyer, and I've been put in a situation where we try to do a bond on a property bond. And as I brought up last time, I don't know why that was turned down, but I got into a lot of problems with that, Judge. And as an attorney representing Mr. Riviera, I could not explain it to him or his family. I understand that there was an individual trying to make the bond, maybe that wasn't a good person to make it. I don't know, but still, Judge, as far as the statutory language goes, I don't know why he's still there and they weren't allowed to make his bond. But then I've also ended up in another situation now where that I wasn't able to give him an answer on his rehab nor explain that to his family. And, I need to, I guess, I can file a motion concerning the property bond and why that was denied and try to get some understanding because I still don't understand that. And, I hope the court understands it. I'm not trying to be smart or anything, but I do got to represent Mr. Riviera. And thus far, as far as what I've been able to explain to him and tell him, Judge, I will openly admit, I don't, due to whatever reasons, I've not felt that I've been able to do that sufficiently as I like to do it. And, I need to either be allowed to give a quick date to file a motion concerning the property bond and get some answers on the statutory readings on that, or get something done with him because he's incarcerated and we've tried 2 different avenues that have not been opened up. And that's fine, but I want to be able to support those things through statutory language and the law and not me sitting here just having to guess at it, Judge. And that's what I'm having to do with Mr. Riviera and his family. And it's making it very difficult on my representation of Mr. Riviera.
Yeah, well, and listen, I don't want to get into a he said, she said thing. So that is what it is. Wednesday was the day he was going to go to rehab. If I let him out, we got to, of course we had been, or was it Thursday? I don't remember which day it was, but whatever day it was, I mean, we were in court. As you all know, on those days that we have revocations, we were pretty much in court every waking hour. And Angel called and talked to my secretary at the end of the day before. And she asked me, she said, "Are you going to do an order?" And I said, "I'm not going to have time to do an order, but you can tell her that I'm not going to change the bond." And that was the message that I gave. So I don't know if it got dropped in translation from one to another or from her to you or what, but that was that. So, there's plenty of,
And Judge, I respect your decision and that's no problem. As far as the property bond issue, that's still something that I am completely lost on and don't understand where we're at on that. So if I would ask the court to allow me to file a motion that I've already gotten ready. I didn't file it because I didn't want to open this can of worms. But I've got to understand about, I think statutorily, everyone in Barron County is legally able to have a property bond. I know that the clerk don't like doing them, but her not like doing them doesn't trump the statutory language passed by the legislature.
I don't disagree with that. I mean, you're right about that. My recollection of the issue was of the bond issue was that the clerk saw that it was not posted by him or it was not property owned by him, and they said that the statute required that if the property was not owned by him, it had to be surety, and they didn't see that I had approved a surety, so they didn't approve the property bond. That's just what I remember that happened, and I haven't gone back and looked at that statute, so I don't know if that's what the situation was or not.
Well, I believe, Your Honor, that's why I think it would be prudent for us to have a hearing, because I don't think the property has to, I mean, Judge, you was in private practice a long time yourself, and you know yourself that a person don't have to own the property. A person just has to be willing to put that property up. There is some language in there about family members and some sureties, but when you read through the statute, my interpretation of it is there's a unsecured bond, a surety, and a property bond and a cash bond. Those are all distinct and different, and we don't have to have an approved surety if we have someone with the amount of property that is needed, as long as it's located in with the Commonwealth. And I mean, I've done a lot of bonds, and I'm sure you have too, where there's been two people that put up different properties to get an individual out, and was not owned by the person. So, I really think there's a misunderstanding somewhere, and it might be on my part, but I would like to get a hearing on that as quickly as possible, file my motion and address that issue expeditiously on behalf of my client, because I think I owe that to him, and I think he has a right to have that addressed if he's continuously held in jail.
Yeah, I mean, you can file that. I mean, are you wanting to file it and set it on just a day that's different than a Monday?
And I'll file it, and and we'll have it anytime you want to, Your Honor, or just whatever pleases the court. But
I mean, why don't you file it? Just file it and put it on for next Monday, and then we'll
that's fine.
I have a feeling that we're not going to have a lot of time next Monday because we've got an awful lot on, but if we need to find another day, we'll do it.
Yes, sir.
All right.
Yes, sir. I will file that tomorrow.
All right. Good enough.
Thank you, Judge.
All right. See you then.
All right. Your Honor, I've got James Rice, Miss Gardner brought up. I had very simply put, I had thought I was going to do a suppression motion in that case. Once I reviewed it more in depth last week, I didn't think it would be meritorious. Ms. Gardner's made us an offer that I'm going to suggest to my client to take. It is a probated offer, and I would ask the court if we could just put him on for next Monday to do that.
Nice.
Or 2 Mondays or whatever Ms. Gardner and the court wants to do.
Whichever Monday is less busy, but I don't know which one that would be.
Well, I won't object to that at all.
So,
matter of fact, if we could do it on a revocation day or something, if that'd be, well, those are never easy. If there's an easier day to put it on, I would be all for that too.
Well, I'm getting ready to take a plea on Friday morning. You want to do it on Friday morning?
That's fine. Well, wait, I got to be in court Friday on that divorce. Right? When? As long as I can get it done before 11:30, Judge. I've got family court again, 11:30. I'm really looking forward to it.
I will have you out of here by 11:30.
Yes, sir.
We'll do it at 9 o'clock.
9 o'clock Friday. Okay.
And And you have the paperwork, Johnny, correct?
Yes, ma'am. We do.
Okay.
The judge, on the other case I've got is Kyle Gardner. We've got a trial date set on him. I haven't got to talk to him. I'll try to go this week, but I would just ask to leave his trial date on and move forward. We got a trial on him, don't we, John Gardner?
I don't think we do.
No, I'm sorry, we don't have a trial date set.
No.
It seemed like to me the last time, and you guys obviously know more than I know about your negotiations, but it seems like to me one of the issues that came up was, like the Metcalfe County deal, whether there was, I don't remember if there's been an indictment or whether there was going to be an indictment, or because I'm not even sure we've ever gotten anything, even been in court on that. I can't recall.
I don't think
There has been an indictment. Everything is indicted at this point. I mean, all three cases have been indicted.
Yeah. And it might have been.
arraigned him.
Did we do an arraignment on that case over there yet? Crystal says yes, but she doesn't sound real confident.
I think we have to, Judge. I can't remember when it was. It was back in the fall, I believe.
So when is that? Is there another pre-trial?
November 24th.
Yeah. Yeah, we had kind of set we had set the pretrial over there to kind of track along with this case, so we hadn't set another one over there.
Yeah. And I'd given an offer out in the original case. I had not given an offer out since the new cases have been indicted. Johnny was going to go up and talk to him at the jail and get back with me, and I was going to wait till then, till we had a discussion.
Well, if we could do that, I hadn't talked to Mr. Gardner due to the COVID and everything's went on. I will get up there this week to talk to him for certain. And I'll get with Mr. Gardner if that would please the court. I don't see any need to set him off more than, 2 weeks, maybe?
Hold the phone for just a minute here. Give me just a second. Here I come. All right, here's what we'll do. We'll set Mr. Gardner's cases over. You know, I don't really care whether it's a week or 2 weeks, whatever you want to do, Mr. Bell.
2 weeks would suffice, Judge.
All right. So that'll be May the 3rd, 1 o'clock. All right, thank you.
Thank you. Y'all have a good day.
You too. All right. All right, let's see. Bonnie, do you got Danielle Cordes?
I do, Judge.
Cordes. Wrong, very different. I think I saw Mr. Price get on here.
I jumped back on, Your Honor.
Yeah, so we've got Ms. Cordes. Bonnie, can you have her come up to the camera?
Judge, in this case, Mr. Price actually came by the office. I can't remember if it was Thursday or Friday, Greg, but one of the two. And we discussed the case, discussed some issues related to discovery. I've got to, there was a phone dump that was done in an agency down in Nashville. It was brought over by the sheriff's department. When I put it in to try to download it to give it to, Greg, it said the file was corrupted. And so they're having to, give me a new record of that. And as soon as I have it, I will give it to Greg. That'll be the same in Manth as well. We discussed a couple other issues in the case. I think he needed to speak with his client, and then so that's where we are at this time.
And Your Honor, that's the sum and substance. There were some hurdles we needed to get over, and the prosecution's worked fairly diligently at that and taking care of those issues. And I need to talk to Ms. Cordes about that. Whenever we were here last time as well, we talked about her bond, Your Honor. I haven't seen an order on that bond. Really, right now, she's in a position where she's on disability, Your Honor. That's placed on a debit card. That debit card's at her old residence. She has some expenses coming up. I know she has storage buildings and just the typical thing that the court deals with people that are in there. I think this is going to resolve. We had to get over those first hurdles, get this resolved, and I think it will. But right now, if she can get out and just take care of a few things, even if it's on a furlough basis to where she'll have to report after 48 hours, but she's really kind of in a panic state, just trying to get that stuff taken care of.
Yeah. I understand. And I do recall our prior conversation. I would tell you what ended up, and this is, I mean, obviously it falls on me, so I'm not blaming anybody else, but I try to keep all the files if I take something under advisement. and keep a little stack of them. And then at the end of court, I take them in my office and work through them. And this one did not get in that stack. So I did not obviously take it in there and do an order. And that is, that's no excuse. That's an explanation is all I got. But I've got it right here right now, and I am going to put it, in fact, I'll put it with my key. That way I know I've got to walk out of here with it. And I will see what I can do. What I want to know is when you all feel like you want to come back, and then I'll look at it in that context, and we'll see what kind of plan we can do, and I'll try to get something done for her between now and then.
And Your Honor, I would like to, after hearing some of the previous pre-trials and people trying to set dates, if we can get a trial date, and I understand, and Mr. Gardner and I have been working this out and it's going pretty smoothly, but worst case scenario, I don't want to find us in June or July looking for a trial date that's going to be next August.
Yeah.
So if we can set a trial date now and just have an end time and make sure we're in the calendar, and then maybe set another pre-trial for 4 weeks out.
Greg, I mean, this is just an observation. I don't really, if we have another pretrial in a month or so, I don't think our trial calendar is going to get really significantly worse than it is right now. It's just everything's set at this, point. And I don't think there's going to be a lot more civil cases, that come in the meantime, or could be. But as far as criminal cases, I don't, foresee it getting a lot worse.
And right now, Your Honor, are we still looking at like a December if we set a trial date now?
Well, if you all, it depends on how much time you would need, because I've got, 2 days here and that kind of thing. It's when people are looking for 4 days or 6 days or something that it gets just a lot harder to do. But, I could take care of 2 days in, probably in August.
Okay, well that would be, I think it would be closer to 3. That would be me guessulating.
Yeah.
Yeah.
I could set it. I have a civil trial August 25th, 26th, 27th. It's just kind of a slip and fall kind of thing. I mean, and if all those people, I mean, we know when we set them, they understand that I might have to bump them for a criminal trial, and particularly not saying that I know one way or the other, but particularly if it happens to be one where people are in custody, they know it's going to get bumped. So that's just, we set those civil trials just because I didn't want to say, all right, I'm not going to set any trials for you guys for a year, and I'm going to use that whole year for criminal trials. So we went ahead and set them, but they all know that, if they don't know, they should know, and they're going to find out that they might get bumped,
Okay. And if we could,
some trials I don't want to bump because they're so complex and you've got so many witnesses. This isn't one of those.
Okay. And are you expecting on May 1st, we're going to be at in-person, so that May 3rd date, we would have in-person hearings?
Yes.
Could we push it?
But our jail, we still won't be transporting inmates up here in person because they can't stay apart. We'll do those by Zoom.
And that's where she's going to be stuck. Is she still going to be there? The next time, I would think, if we can come back May 17th, the phone dump is not where I'm most concerned. It's just discussing with the Commonwealth where we'd like to go with this. So would that be fine, Mr. Gardner?
That's fine.
And then if nothing else, we'll set a trial date at that point.
What day did you say?
May 17th, Your Honor.
All right. That's fine.
And Mr. Gardner, do you mind if I call you Wednesday and Thursday to discuss this a little more?
That'll be fine.
And Danielle, give me a call whenever you get a chance, all right?
All right, I will, sir.
Thank you.
All right, so May 17th it is. We'll see you then. I'm keeping this file. I'll take I'll consider your request about letting her out for a few days to get some things taken care of.
I appreciate that, Your Honor.
Thank you.
Thank you, Your Honor.
Micah Manth.
Judge, Zanda sent me an email saying that she is handling this case now. I emailed her back. If she overheard the conversation with Greg, that's the same issue that I was talking to her about in the email. That we've got to get this phone dump and then get it to her. We have not really had any settlement negotiations in this case at this point. There actually is some ongoing investigation at this time. So, and obviously, if there anything that results in that, we'll provide that as it comes in.
Okay, what day would you like me, I mean, do you think that May 17th would be useless under the circumstances?
We might have an idea on the phone dump, but, you know, I mean, we could have some preliminary negotiation if we want to, but at this point, it's not, you know, the sheriff's office is still collecting evidence this time.
Yeah. Well, how about we do that just because, and that actually probably works okay because I was thinking Miss Myers was going to be in trial most of that week before and I didn't want to hang her up, but if there's not that much negotiating that's going to go on, we'll just put it in there as a time to kind of come back and look at whether there's any evidence issue that needs to be discussed. Okay?
That's fine with me.
It's fine.
Good deal. So May 17th at 1 o'clock. All right. Thank you. Can I talk to you more on the, will you change the attorney? Okay. All right. Let's see. Bonnie, who we got left?
Virginia Rodriguez.
Oh, yeah. Ms. Rodriguez is on because there's been a motion to revoke, and that'll need to be set for a hearing. I believe we can set that next Tuesday at 1:30. I do not know who will be handling this on part of the DPA, but I need a reappoint. So.
It would be me, Your Honor.
Okay, good deal. So that's going to be April 27th at 1:30.
Okay, is there any chance of me getting out?
Not between now and when we have that hearing next Tuesday. I don't know how the hearing will go or what'll happen, but I'm going to keep you, Ms. Rodriguez, in custody until we can have the hearing, okay?
Okay, what day next week?
It's next Tuesday, a week from tomorrow.
Okay,
Thank you.
yep.
That's all I've got, Judge.
All right, Bonnie, thank you.
Thank
What?
you, Judge.
All right, let's see, who else do I have?
Judge, did Fred Roman get continued?
Who now?
Fred Roman.
Yeah, it was one of Greg's that we had to move.
Is that on the 3rd then?
Correct.
Okay, thank you.
All right, yeah. These are the things I've got left. David Hughes.
Your Honor, that's mine. I don't know if you recall last week, I had actually given him an earlier court date, and I think the court actually reset the court date to May 24th. We've actually worked out the deal. I was supposed to have met up with Mr. Hughes yesterday to get his signed paperwork, but we just couldn't connect. I suspect that we have an agreement. I'm just waiting for his paperwork. So I don't know if you want to just keep it on for May 24th or try to set it over for April 26th, and I'll try to get him online so that he can actually, I'll try to get the paperwork from him and then get him online to get that guilty plea entered.
I mean, I guess I'd just soon do it next week if you think you can do it.
I'll try to get a hold of him on that. He's usually pretty good about contacting me back, but I just couldn't connect with him yesterday.
Okay.
Is there anything you said you don't have the paperwork?
You've sent me all the paperwork. He's got the paperwork in hand. I'm just waiting for his signed paperwork. He didn't have a scanner.
I got it. Okay. I was making sure I sent you everything. Okay, we're good.
You sent me everything, I believe, and it's just a matter of getting the physical paperwork in hand so that I can file it.
All right, so we'll give it a shot, okay? Andrew Johnson?
Judge, that one's mine. I haven't been able to contact him in some time. I remember the last time we were in court in person, we had a deal pretty much worked out, and if I remember correctly, we had a deal worked out, and I think the very next week we got shut down. As when we got shut down permanently, or shut down for this time or something. So we hadn't been able to get the paperwork done. So if we could give me a week and see if I can get a hold of him, we might be able to resolve this one next week.
Okay.
May I speak?
Who is that?
Andrew Johnson.
Oh, yeah.
Yeah.
I was trying to contact you. It was about a month or so ago. I lost my wallet. It got stolen along with like $250. I couldn't find your number anywhere, and I was gonna try and contact you, and I lost your card and everything else.
Okay, have you got something to write my number down with?
Yes, I do.
Okay. You ready? Tell me when you're ready.
I'm ready.
833-385-6055. Give me a call sometime tomorrow afternoon. We should be able to get this hopefully worked out.
Alrighty. What? Tomorrow afternoon?
Yeah, tomorrow afternoon. Anytime after 1 o'clock.
That's fine. I'm off work tomorrow. I'm actually about to go in.
Okay.
All right, so you want to try this Monday and see what happens?
Yes, I think we can get this one resolved pretty easily because I have a new offer in the case, and I think he was considering the last time we had court. So,
you said the last four was 6055.
6055. Yep.
All right.
All right, we'll see you then. Joseph Morgan, that was one of those McCracken County jail deals where we've sent them, I don't know how many times, and they say
They're worse.
They didn't.
Yeah, they're worse than Roeder. Even trying to get a hold of him. And last time I was able to speak to him, which was like 2 months ago, he said he was going to get out sometime in April, but if he did, he's not contacted me. So
Darlene normally checks that to see if they're in custody, and he's showing that he's still in the McCracken County Jail.
Okay.
He seemed to be very confident about his grasp on legal matters and his secret knowledge of the system that the rest of us don't have. I remember that. He was kind of one of these lingo guys, like he knows all the lingo.
Good. Xanda's gonna love me. I'm gonna give that case to her. Sorry.
And he can be your paralegal.
He was very confident. I'll put it that way.